And now it's time for another case law update. Today we're talking about Dow Construction, LLC versus BPX Operating Company, a recent decision out of the Fifth Circuit Court of Appeals that tackles a hot issue in Louisiana mineral law, whether unit operators can deduct post-production costs from a mineral owner's share of proceeds when that mineral owner hasn't leased with the operator, and what happens if the operator misses certain notice obligations. Here's what happened. Dow Construction leased property within a forest drilling unit created by the Louisiana Commissioner of Conservation. BPX was the unit operator. Under Louisiana's forest pooling laws, the commissioner can combine separate tracts into a single unit to prevent waste and ensure that each owner gets a fair share of the production, whether they agree to it or not. Here's the issue. Dow didn't have a lease with BPX or its predecessor Petrohawk, who was the original operator of the unit. Dow sent a demand for well cost information to Petrohawk, but Petrohawk did not respond. BPX sold the production from the unit and sent Dow its share of revenue after deducting Dow's share of well costs and post-production costs like marketing, compression, and transportation. Dow, of course, objected, stating that BPX did not have the right under Louisiana law to deduct post-production costs from Dow's revenue, and Dow also pointed to a Louisiana statute that imposes a forfeiture of the right to contribution for the cost of drilling if the operator fails to provide detailed cost reports demanded by an unleased owner. BPX pushed back with several defenses, claiming that Dow wasn't the kind of party protected under the statute, and that it had the right to deduct costs under Louisiana's doctrine of negotiorum gestio. But here's where the Fifth Circuit and the Louisiana Supreme Court made things interesting. The Fifth Circuit held that unleased interests under Louisiana statute mean interests not leased to the operator, not necessarily interests that are unleased altogether. Since Dow wasn't leased to BPX, it qualified. The court sided with Dow on that point, affirming the district court's reading of the statute. Then came the negotiorum gestio argument, the idea that BPX should recover costs because it acted to protect Dow's interests without a formal agreement. The Fifth Circuit rejected that too, based on a binding answer from the Louisiana Supreme Court in the Self versus BPX case, which we reported on in my buddy Tim Powell's podcast last year. The Self Court ruled that negotiorum gestio only applies when someone acts without authority. But here, BPX's authority came directly from a Louisiana state statute. That statutory authority meant BPX wasn't a gestor acting out of altruism. It was an authorized operator and couldn't use negotiorum gestio to justify its decisions. That ruling from the Self versus BPX case essentially shut the door on a broad reimbursement theory for post-production costs under civil code quasi-contract doctrines. Therefore, in the Dow case, the Fifth Circuit vacated the lower court's order that had allowed BPX to recover those costs and sent the case back for further proceedings. So what does this mean for mineral owners and operators? Louisiana operators should be cautious about deducting post-production costs from unleased parties, especially when no joint operating agreement or lease exists. You may have statutory authority to market production, but that doesn't give you complete freedom to recoup post-production costs. If you're within a forest pooled unit in Louisiana and you're not the operator, you may want to check and see what costs, if any, are being deducted from your revenue. That's it for this case law update. Thanks for tuning in. I'd like to thank Kanika Draksharam, a law clerk in our Houston office, for her help on this update.